Mike Davis, we've seen a lot of his work over there doing the battle against the Democrats in the courts. The DC bar is saying that Clark needs to lose his law license because of a letter that wasn't ultimately sent that was based on the Fani Willis prosecution in Georgia. The bar recommends my disbarment for questioning the 2020 election in Fulton County, Georgia, which was rigged. This is war, says Mike Davis. He is, of course, the founder of the Article 3 project, and we've seen a lot of his work over there doing the battle against the Democrats in the courts. And maybe he's not the founder, but he's over at Article 3 project. Now, he's referencing this DC bar report that came out against Jeff Clark, who is a former Trump DOJ official. And the DC bar is saying that Clark needs to lose his law license because of a letter that wasn't ultimately sent that was based on the Fani Willis prosecution in Georgia. He should be disbarred, lose his license. But you may remember that there was another person called Kevin Clinesmith, who is this person right here, who was only temporarily suspended. And we'll refresh our recollection about what he did. He was convicted of a crime, and he only got suspended in a stipulated penalty, whereas Jeffrey Clark, who was not convicted of a crime at all, is now going to lose his license because the DC bar, the Board of Professional Responsibility, is filled with maniacs. Here's the backstory. And Mike Davis says, we're going to really not take kindly to this. So the DC bar is going to have some added scrutiny, and well-deserved. Now, here was Jeff Clark, the man we're talking about over on X. He's now, again, working with the Trump administration as the OMB acting aura administrator of the CFPP, former US DOJ double assistant AG, admin law expert. The guy is impressive. Now, he said, the DC Board on Professional Responsibility, the bar, recommends my disbarment for questioning the 2020 election in Fulton County, Georgia, which was rigged. But we still can't see the ballots there from that election 5 years later because they don't want you to see them. Can you say, what are they hiding? Yeah, that's right. And he's reposting this, says the GA, this is from Liz Harrington, saying the Georgia Election Board is now voting to seek the assistance of the DOJ, since now Pam Bondi's got some control on this, to bring any action necessary to actually get the voting records of Fulton County for the corrupt 2020 election. Fulton County is still refusing to turn over their results. They've got a subpoena, they think they're above the law, and they're not willing to comply. So here's a little bit of this.
Still incomplete with respect to basic documents required by law to be maintained, despite the extensive efforts of the board to exhaust all remedies available to it, including the lack of a response to a subpoena issued by the board issued to Fulton County. Now, therefore, be it resolved that the board calls on the assistance of the Secretary of State to assist it as fully as possible and suggests that the Secretary of State and the Attorney General seek the assistance of appropriate local authorities or federal authorities, including the Department of Justice, to take any action necessary to bring a prompt resolution of these issues, including obtaining all necessary voting records and documents.
Let's go. That's what we want to see. Fani Willis freaking out right now, calling Nathan Wade. Hey, baby, I'm just stressed. I don't know. You want to go on a cruise? What's going on? Yeah, I stole some more money from Fulton County. Sure, let's go. So James Burnham, he says, in support of Jeff Clark, I worked closely with Jeff Clark in both Trump administrations. This is an outrageous weaponization of the bar ethics process, one that can be turned against any lawyer serving in the government at any time. All steps must be taken to push back. And he's right about that. Tom Cotton said, this is outrageous lawfare. Jeff Clark is being targeted because he's a conservative delivering regulatory reform for Trump. The DC bar is a disgrace, and everyone involved in this smear against Jeff should be held accountable. Ooh, let's go, Tom. We appreciate that. Yeah, and so the question, of course, becomes, well, if Jeff doesn't have a license, can he act in any legal capacity? And does this current position require him to be a lawyer in any way, shape, or form or anything like that? Or does he have a license in some other jurisdiction? Or, does it impact his role in any way? In other words, is it a targeted attack to try to take somebody out of a position based on their licensing, right? It would be very smart of the Democrats to do that. And in fact, there's a report that that's exactly what they're doing. Now, Ed Martin said, me too. I stand with Jeff Clark. Gunther Eagleman, shout out. Ed Martin, me too. And he was there over on the DC trip. I got to see him pop into the room, shake some hands with Chuck Grassley, and then leave. But Cernovich also says, the Senate with Tom Cotton needs to conduct oversight into these rogue state bars. John Eastman, now Jeffrey Clark, being disbarred for writing a legal memo to a client. That's what happened. That's all it takes from these maniacs. Julie Kelly also knows Jeff, says, my friend Jeff Clark is brilliant, tough, and unflappable. Whatever steps can be taken to punish these partisan hacks at the DC bar must be pursued. And Sean Davis really made this point, said, Kevin Clinesmith, you remember him, he's part of the FISA fraud with Carter Page and the Hillary hoax and the Obama coup and all of them. Kevin Clinesmith, who we've talked about here before, is a convicted felon who fabricated evidence as an FBI lawyer so that the FBI could fraudulently obtain an illegal spy warrant against Carter Page on the Trump campaign. The DC bar restored his bar license after he was convicted. Jeff Clark's been convicted of nothing. And so these people are criminals. Now, let me show you just a little compare and contrast on these, right? So Jeffrey Clark got this memo from the DC Board on Professional Responsibility. It's not a final order of discipline, but it's a recommendation on what happens next. And you can see it's in the matter of Jeffrey Clark. Now, these lunatics wrote 111 pages. You can see this at the top of your screen right there. 111 pages on this dude, okay, just to smear him and to make it hurt. It's like a book, all right? And that might be normal, except that's not what they did in the Kevin Clinesmith case. You see, this one over here is Kevin Clinesmith. He just wrote 21 pages. It's like a fifth. It's like less than a fifth. They had, and you can see it's the opposite, okay? It's a cover-up. It's just something where they're like, well, and Clinesmith was bad, okay? Anything remotely resembling what Jeffrey Clark did, which was writing a memo saying that we should investigate these things and advising that there are some steps that you could take that never ultimately went to fruition. And so they're going to write 111 pages on it. It's not even worth spending the pixels on your screen to go through it. But you understand what we've seen here before. In summation, they say that we need to disbar him from the practice of law. We further recommend that his attention be directed to the requirements and talk about how he can possibly be reinstated. And let's see, any other sanctions, aggravating factors, false assertions, doesn't rise to the level of pervasive dishonesty, whatever. All right, so they go on. It's just, we'll see who these people are. Leslie Spiegel and Mr. Walker. Be interesting to learn more about them. But here is what they wrote for Kevin Clinesmith, okay, an actual convicted felon who actually committed a crime, didn't send a legal memo or advise clients about possibilities. This happens all the time, right? Lawyers will come up with ideas and they'll investigate it. Well, what if we try this? What if we make this argument? What if this person, can we do this? Actually, no, the rules say you can't do this, or there's no evidence of that. This could be a possibility. Let's go see if there's evidence. It's called identifying issues and identifying problems. I wonder if the cop did this thing. Let's go see. Did he do that? Does he have a background? Does he know this person? Is there a conflict here? Let me go see. Maybe there is a conflict. Let's go investigate conflicts of interest. Well, you're going to investigate conflicts of interest? Why? Because you're trying to obstruct their justice? Well, kind of. Yeah, we're a defense attorney. We're investigating fraud. So yeah, we're trying to stop the fraud. That's what the investigation is all about. That's what Jeffrey Clark was doing as a lawyer. That's the job of a lawyer. But Kevin Clinesmith was also a lawyer, and he committed a crime, as we'll find out here. Now, this matter became before the hearing, and everybody's here. We reviewed some of the documents, and now we approve the negotiated discipline of just a 1-year suspension. Okay, this guy was lying and defrauding the FISA court. 1-year suspension for him, but Jeffrey Clark, who just wrote a memo, disbarred by these maniacs. So with Clinesmith, the allegations were brought to the attention of the Disciplinary Council from a DOJ Office of the Inspector General report dated December 2019, and he took a guilty plea for making a false statement in violation of U.S. code. Now, he's voluntarily acknowledged his misconduct, and he says that he's a member of the bar. He pled guilty in the District Court of Columbia. As a part of his guilty plea, he stipulated that had the case gone to trial, he would have been found guilty. And he admitted to these facts in his guilty plea. We talk a lot about a factual basis that you lay out for the court so that the court can ask the defendant, did that all happen? You say, yes, they did. Okay, great. I find there is a factual basis for this guilty plea because you can't plead guilty to something you didn't do. If they lay out the facts and you're like, what? I did what? No, I didn't do that. I'm not pleading guilty to that. Then the judge will, of course, not accept the plea. But from July 12th, 2015 to September 21, 2019, Clinesmith was employed at the FBI, Assistant General Counsel for National Security and Cyber Law. As part of his duties and responsibilities, Respondent Clinesmith assisted with FBI special agents and more, and he also went to the FISA court. On July 31, the FBI opened an investigation known as Crossfire Hurricane, fake made-up scandal, and trying to spy on the Trump campaign, saying they're coordinating with the Russians. Obama knew about it, Hillary knew about it, CIA knew about it, and FBI refused to investigate it. By August 16, 2016, the FBI had opened individual cases under Crossfire Hurricane investigating Carter Page. Now, Respondent was assigned to provide legal support, this is Clinesmith, to FBI personnel working on this. One of his tasks was to talk to other people. As part of his responsibilities, he provided support to the FBI, and he had to complete FISA applications. There were a total of 4 of them targeting Page. This guy wrote 4 of them. Each alleged that there was probable cause that Page was a knowing agent of foreign power. On August 17th, prior to the approval, OGA provided certain members of the team, but not Clinesmith, a memo indicating that Page had been approved as operational contact, and there were some concerns about Russian intelligence. The 3 of the FISA applications did not include Page's history or status, and prior to the submission of the 4th application, Carter Page publicly stated that he had assisted the U.S. government in the past. During the preparation of the 4th FISA application, an FBI supervisor agent asked Clinesmith to inquire about whether Page had ever been a source for that agency. Clinesmith knew that if Carter Page had been a source, then that information would need to be disclosed. Okay, if I look into this, then I find out that that's right, then I have to disclose this. On June 15th, so in other words, he knew. Respondent Clinesmith sent an email to a liaison stating, "We need some clarification on Carter Page. There's indication that he may be a redacted source. This is a fact we would need to disclose in our next FISA renewal." Like, is he intelligence for someone else? To that end, can we get 2 items from you? Source check, is Carter Page a source in any capacity? And if he is, what is his designation, source, or whatever type of source he is? Later that same day, the liaison responded with a list, but not copies of memos previously provided to other members of the Crossfire Hurricane team, including a reference to the above referenced memo, as well as an explanation that they use. They say, well, the designation shows that the encrypted individual is a U.S. person. We encrypt them when they're reporting to us. My recollection is that Page is something redacted, but the memo will explain the details. So Page is an informant or a source. If you need a formal definition for FISA, please let me know. We'll work up some language, get it cleared for use. Now, it was not typical for someone in Clinesmith's position to review the memo. His role generally was to conduct legal reviews of FISA applications, not to obtain, review, or evaluate underlying documents related to applications. Okay, so they're writing an excuse for him. He kind of didn't know what he was doing. It's normally the case agent. As such, the same day he got the email, he forwarded it, including a list of memos that would explain the details to the case agent and the supervisor. Upon receiving the email, the case agent supervisor responded by telling the agent that she would pull these memos for you tomorrow. He said, "Thanks so much. We're digging into the memos now. We'll look into it." The following day, Clinesmith also forwarded the email to a DOJ attorney drafting the FISA renewal. The DOJ attorney replied to the respondent, "Thanks, I think we're good. No need to carry it further." Then on June 19th, FBI special agent followed up with an instant message to Clinesmith. "Do you have any update on this source request for Carter Page?" During a series of instant messages between the two, Clinesmith indicated that Page was a subsource, was, quote, never a source, and that the OGA confirmed explicitly he was never a source. When asked whether he had that in writing, he said, "I do, and I would forward a copy to you." Immediately following that, he forwarded the email to the SSA with alterations that Clinesmith had made so that the email read as follows. Okay, this guy committed fraud. He changed the report. The designation redacted to show that the encrypted individual is a U.S. person. We encrypt the U.S. persons when they provide reporting to us. My recollection is that Page was or is a designated redacted and not a source, okay, in bold. Added that in, just typed it in there. He knew that the original email did not contain the words "and not a source." Respondent knowingly and willfully altered the email. Clinesmith changed it to appear that they wrote in there it was not a source. The DC bar is like, that's okay. Give him a license. That's okay. he can keep his license. Relying on the altered email, this agent signed off on the FISA application and submitted it. It did not include Page's history or status with the OGA. Respondent violated the following provisions of the District of Columbia Rules of Professional Conduct and the DC Bar Rules. All these rules. 8.4. He committed a criminal act that was impacting his honesty, trustworthiness, or fitness as a lawyer. He made a false statement, and that he engaged in conduct involving dishonesty, fraud, deceit, and misrepresentation, and that he was convicted of a serious crime as defined by the DC Bar, which is a felony. Now, he agreed to the negotiated discipline, no promises. He wasn't being subjected to coercion. He's fully aware of all of the penalties. Disciplinary actions are as follows. He's never been in trouble before, and it was not his intent to deceive. Blah, blah, blah. This guy changed a report to get a warrant to go file against the Trump campaign person. DC Bar's like, whatever. We find that he knowingly acknowledged the facts and misconduct, and we reviewed the facts, and he did violate the rules, but the agreed upon sanction of a suspension is justified. And this isn't a crime of moral turpitude, which is wild. Moral turpitude involves intentional dishonesty, which is for the purpose of personal gain, rather than simply misguided actions. They're such scammers. It's clearly a crime of moral turpitude. He had intentional dishonesty. He changed the report to get a different outcome and lied to everybody about it because he wanted his warrant to go through because he hates Trump. This hearing committee is required to evaluate independently, and we conclude that this is not moral turpitude. Making a false statement is not moral turpitude. All right. So wild. But I guess Jeffrey Clark writing a memo is. So you can see the 1-year suspension is not unduly lenient. No, it's not. Okay. He entered a guilty plea and he's accepting responsibility for this. So you can see this came out against this dude from Rebecca, Dr. Robin J. Bell, and Arliss. Man, it'd be great to learn more about who these people are and see what their backgrounds are because they seem like partisan biased hacks from our reading. But they wrote 21 pages for Clinesmith, 111 pages for our friend Jeffrey Clark, go through aggravating factors. I mean, it's just insane. We don't even need to waste the pixels on it. But what we know is that they are going after Jeffrey Clark, and a lot of people are circling the wagons to defend him. Mike Davis saying this is war. And so we're going to keep our eye on this. We'll investigate what Jeffrey Clark's options are, right? This is just a recommendation. So I'm sure once there's a final order, there will probably be some appellate options, and we'll keep our eye on that. But it's nice to see senators and others like Eagle Ed Martin are coming out to support Jeffrey Clark, who deserves our support. And of course, he's got it. So we'll keep our eye on this one, my friends. Thanks for subscribing and joining as we do.